friends, and happy holidays. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. In this episode, we explore the constitutional legacy of Justice Robert Jackson, including his sublime writing style, his service as chief prosecutor at Nuremberg, and the lasting legacy he left on debates over presidential power. Joining the conversation are John Q. Barrett, discoverer and editor of Robert H. Jackson's acclaimed book, That Man, an insider's portrait of Franklin D. Roosevelt, and writer of the popular blog, The Jackson List. Gerard Magliocca, author of The Actual Art of Governing, Justice Robert H. Jackson's Concurring Opinion in the Steel Seizure Case. And G. Edward White, author of Robert H. Jackson, A Life in Judgment. This program is presented in partnership with the Robert H. Jackson Center. It was streamed live on December 8th, 2025. It is so exciting to convene today the Robert Jackson Dream Team for a conversation about the life and legacy of Justice Robert Jackson. I have admired Jackson ever since law school as one of the greatest writers ever to sit on the Supreme Court. And in addition to that distinction, for his path-breaking opinion in the Steel Seizure Case, which is considered perhaps the leading Supreme Court opinion on executive power, and then his performance at the Nuremberg trial, where he successfully prosecuted the Nazi war criminals. And then lo and behold, because the timing gods are with us, we now have a new Hollywood movie that's just been released called Nuremberg, and everyone wants to know about Robert Jackson. So hearing the call, we've convened three of the greatest Jackson authorities in America, who also fortuitously have new books out about him, to teach us about Robert Jackson. So Professors Barrett, Magliocca, and White, it's an honor to welcome you back to the National Constitution Center. Let's begin with you, Professor White. Why did you choose to write a biography of Robert Jackson, and what would you like our listeners to know about him?
Well, there were several reasons. First of all, I had written an essay on him in the 1970s in a book called The American Judicial Tradition. His first edition came out in 1976, and I found him really quite fascinating, in part because I thought that he had so much talent that would have been appropriate to be an effective Supreme Court justice, and yet he, in some ways, wasn't as effective as he might have been, and perhaps didn't like being on the court as much as he may have anticipated when he was first named. So I thought there might be more to say about that. And so after writing some other books, I eventually turned back to him. The other reason has to do with Jackson's scholarship generally. Jackson's scholarship was affected for many years by two phenomena. The first was that Eugene Gerhardt, a lawyer in Binghamton, New York, published I would say, largely authorized biography. Jackson had cooperated with him from the beginning while Jackson was still alive and on the court. And Jackson had furnished Gerhardt with a number of his papers, which Gerhardt used. The Gerhardt biography, therefore, was very detailed and thorough, but it was also quite unduly, I would say, favorable to Jackson. Jackson's papers reveal him to be candid, but also apologetic. He's something of an advocate for himself in controversial matters, and Gerhardt kind of uncritically repeated that. But the book was sufficiently thorough that it, I think, deterred other scholars for a while. Felix Frankfurter appointed himself custodian of Jackson's memory after Jackson died. Frankfurter was a close friend of Jackson's on the court. And when Frankfurter found out about the forthcoming Gerhardt biography, he tried to prevent its publication by writing to Jackson's son, Bill Jackson, and saying, I can't imagine this is going to be any good. And Bill Jackson, of course, declined that invitation. But Frankfurter was determined to get what he thought would be a more appropriate biographer. So he commissioned Phil Kurland, University of Chicago Law School scholar and a very distinguished constitutional commentator, and arranged to get the Jackson papers transferred to Kurland. And Kurland worked on the biography for many years, but never completed it. But while he was doing it, he basically had exclusive access to the Jackson papers, and of course that deterred other scholars. Finally, when it became apparent that Kurland wasn't finishing the biography, Bill and Mary Jackson's, Robert Jackson's son and daughter, transferred the papers to the Library of Congress. The Jackson papers are very rich and very detailed and very voluminous, and represent a kind of considerable undertaking to go through them. And then in addition, COVID came along and the manuscripts division was shut down for a couple of years. So all of that, I think, has contributed to perhaps less work being done on Jackson. Now, John Barrett has labored hard during all this interval, working away, but it's a formidable task. So I just wanted to, in a way, reintroduce the public to Jackson, who I find to be a fascinating figure with a remarkable career and some interesting idiosyncratic features that I tried to get at in the book.
Thank you so much for sharing all that. Fascinating that your interest began with your path-breaking book, The American Judicial Tradition. I learned so much from it in law school, and I want to recommend it to our viewers as just a model for literary judicial biography and combining intellectual portraits of the judges' philosophies with their lives, and an apt subject in Robert Jackson, who cared so much about writing as well. Gerard Magliocca, you've just written wonderful biographies, many of which we've discussed on the NCC podcast, including most recently of John Bingham. Why did you decide to write about Robert Jackson and to focus on his decision in the Steel Seizure case?
Well, first of all, I teach the opinion every year to my constitutional law students. And sometimes after a class, a student will say something like, if I want to learn more about this case, what would you recommend? So now I can recommend something I wrote, which is a nice option. But more seriously, there are very few cases, and indeed very few opinions, that merit an entire book devoted to that single case. And there was not a book devoted to the Steel Seizure opinion by Justice Jackson, though there is a wonderful book by Maeva Marcus on the Youngstown case, which is still like the leading authority to consult. It's also a case and an opinion that is very much in the news now. So it isn't as if you're writing only about an opinion from long ago, which was of interest at the time, and now is more of something only for historians. The sort of scope and meaning of Justice Jackson's opinion is being discussed all across the country in courtrooms in challenges to various presidential actions. And so it seemed appropriate then to go and do a book on that subject, especially when you have, as Professor White said, such a rich source of materials. That is, Jackson kept all his drafts of his opinions and a lot of other supporting materials. So it's not difficult to sort of reconstruct a good deal of what was going on when the opinion was being thought through, which is not always the case for judicial opinions. So for all of those reasons, it seemed like an ideal subject.
Wonderful. Thank you so much for that. And John Barrett, Professor White notes that when Jackson family members discovered a folder about Roosevelt in Jackson's son's apartment, they approached you, and you've been writing a biography of Jackson, and you've been curator of materials on Jackson over the years, and you began to reconstruct the Roosevelt book for publication. I should say, incidentally, is it That Man in the White House? It's a marvelous book, which I devoured a couple years ago. Just a short, vivid series of impressions of Roosevelt. And the most memorable part is they're fishing together, and Roosevelt can relax and gamble for low stakes and tell jokes and be more unbound than he ordinarily was. So tell us, why did Bill Jackson approach you, and what have you viewed it as your mission during the many years that you've been running the Jackson listserv and been the curator of Jackson's legacy?
Well, I had known Bill Jackson in what turned out to be the last year of his life, and that was when I was just beginning to write about Jackson. And I learned that Bill had been with his father at Nuremberg as his executive assistant, and so I had a chance to discuss that directly with William Jackson, who was a very distinguished New York lawyer, had been the leader of Millbank Tweed. And that really lit the candle of my interest in Jackson. Jackson's words had grabbed me as they grabbed you when I was a law student. When I worked in the main Justice Department building in Washington, D.C., you sort of feel the aura of Robert Jackson in the hallways and see his portrait, and people quote and revere him. I worked on some litigation, Morrison versus Olson, in which Justice Scalia ends up prominently quoting in his dissent Jackson's speech about the ethical way to be a federal prosecutor. So, one thing sort of led to another. The discovery of the folder that contained the That Man manuscript was Bill's family's discovery after he had passed away. And they knew I was beginning to work on Jackson and gave me the opportunity to figure out what this jumble of papers was and edit it into publication and publish it. And it became a very acclaimed and quite widespread book. It's a portrait by Robert Jackson of Franklin D. Roosevelt. And so it's both biography by Jackson, but it's also very autobiographical, because I think one of the sort of charming and quite distinctive things about Jackson is you meet the man when you read his words. He didn't hide himself in a lot of formality, doctrine, artifice. And so in Steel Seizure, in the materials that Ted has used and gathered, in my own work, working with the pages really is to be in the presence of Robert Jackson and get a sense of what made this fellow tick. And what he had in common with Franklin Roosevelt was that he really was a great statesman. I don't think of him as a judicial figure entirely, although of course he was, but he was only that for 12 years of functional work on the Supreme Court. He was a leading figure in American national life and, after a time, international affairs for a 20-year period. And he really was of a generation when I think statesmen populated the branches of government and the different roles that in a way that's different from our quite siloed and distinct specialties. Jackson was on a Supreme Court that was filled with prospective presidents. Some more in their own minds than in public opinion. But Jackson certainly was one who was a prospective president. And he also was a prospective governor. And he was a prospective cabinet member. He'd been attorney general, but to run war or to run state were offers to him in the 1940s. And so what we have in Jackson is a type. Yes, he never became president. Yes, he never became chief justice. But there's sort of a top shelf American greatness to him. I think of him as an Alexander Hamilton-like figure or a George Marshall-like figure, perhaps an Earl Warren looking back before he was chief justice to when he was nearly vice president and America's leading governor, that kind of figure. And so to have that stature and to have the accessibility of that person is what has drawn me into working on Jackson.
Superb. Someone with the stature of a statesman is a really powerful way to put it. Professor White, your biography is so vivid, concrete, and the word that comes to mind is mellifluous, like Jackson's writing itself. Yours gives us the sweep of his life and ambitions. Tell us about his early life, dating up to his time as Solicitor General, which he considered the best job ever. You have lots of great details about his family, including the wonderful fact that his daughter, Mary, married Kingman Brewster, the future president of Yale, who is Bill's roommate. But I want to get at where you think the essence of his worldview and even his greatness comes from. You quote him as saying that I lived much of my life in a time and environment that was truly and deeply democratic in an economic and social as well as political sense. I'm from the last generation to have had that experience and felt the influence of that kind of democracy. What did Jackson mean by that deeply democratic small town world, and how did it influence his achievements?
Yeah, he's a unique figure, I think, in the 20th century American legal history. He's the last justice on the court to have read for the law, that is to say, apprenticed himself to a law office rather than going 3 years to law school. He went only 1 year in a special program at Albany Law School, where he was given a degree, basically 2 years work in one, that was offered to people who were already in law practice, apprentices in law practice. He never went to college. He was identified as a gifted high school student and took an extra year at Jamestown High School after graduating from Fruberg's High School. But he's growing up in a rural community. His parents are dairy farmers. None of his parents have gone to college. The expectation, to the extent there was one, was that he would go back and work on the family farm. His father opposed his going into the practice of law, didn't trust lawyers, wouldn't give him any money. But Jackson finds his way and is a conspicuous success as a general practitioner in Jamestown, and has an office there till 1934, when he's recruited by the Roosevelt administration. At the time he's recruited, he's making over $30,000 a year, which is a very considerable sum in that period, probably the equivalent of about $400,000 in today's dollars. And so he goes to Washington. His first job is with the Bureau of Internal Revenue Service. He's not done any tax work in Jamestown. He's done a lot of different things, but not tax work. But Jackson is tremendously good at and interested in, I would say, working up roles, professional roles from the ground up, where he learns what to do. He masters the details of his job. He becomes very accomplished in it. People notice it. People covet him for other positions. He moves from one position to another in the Roosevelt administration, from the Treasury Department to the Justice Department, ends up eventually becoming Solicitor General. Solicitor Generalship, as Jackson defined it, was very high on advocacy, which he loved. He had argued cases in the Supreme Court before becoming Solicitor General. He continued to do so as Solicitor General, and low on administration. Jackson didn't particularly like administration, and although he was an efficient worker, he just didn't like the personal details of it, and what he really wanted to do was argue cases in court, prepare and argue cases in court, and he was extremely successful. Now, part of his success, he won great majority of the cases that he argued. Part of it was the court had been shifting in the direction of the Roosevelt administration in the late 30s, when Jackson was doing most of his arguing. And it's really, the timing is just at the point where the court begins to retreat from its jurisprudence, its constitutional jurisprudence that's been hostile to early New Deal programs, and begins embracing some of those. And Jackson is sort of on board with this. But anyway, Jackson, the last thing I want to say about his career in Washington, Jackson gets involved in writing a book about the court packing crisis. The Roosevelt administration lost the effort to pack the court. The plan never got through Congress, never got through the Senate, and eventually died. Roosevelt wanted to commission Jackson to write a book which basically said, well, we lost the court packing fight, but we won the war because the court is now moved in our direction. And so Jackson produces a book called The Struggle for Judicial Supremacy. That book was written largely while Jackson was Solicitor General. It ended up being published in 1941, when just the year that Jackson was nominated to the court. But it was written largely while Jackson, from 1938 to 1940, was Solicitor General. So it's an incredibly meteoric career. And one, if you imagine his origins, was really kind of astonishing. I very much enjoyed writing that portion of the book.
It is astonishing, and it is meteoric. Gerard, let's talk about the Steel Seizure Case. I'll just put on the table what the core of Jackson's concurrence was, so you can react and tell us about where it came from and how it's significant. This is the time when President Truman wants to seize the steel mills in the middle of the Korean War, asserting his power as commander-in-chief. He's sued, goes up to the Supreme Court. He thinks they're going to vote for him because his friend, the Chief Justice, has already assured him that it will. But to his great surprise, the court rules against him. And although the majority opinion is written by Hugo Black, the most influential concurring opinion is written by Robert Jackson, who sets out three categories for executive power. First, he says when the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum. Second, he says when the president acts in absence of either a congressional grant or denial of authority, he can only rely upon his independent power, but there is a zone of twilight in which he and Congress may have concurrent authority. And third, when the president takes measures incompatible with the express or implied will of Congress, his power is at its lowest ebb. So just to go through that again, first, when Congress authorizes it, his power is at its maximum. Second, when Congress hasn't clearly authorized it or denied it, he's in a zone of twilight. And third, when Congress has said no, his power is at its lowest ebb. Hope that was helpful for the audience, just to summarize. But Gerard, where did that come from? Tell us more about the case. How did Jackson's previous cases play into the concurrence, and what else should we know about it?
Well, I think it came from a couple of different sources. The first was his own experience. He starts out the opinion by saying that his own experiences as Attorney General and implicitly as Solicitor General were probably a more important influence on his views of executive power than any case or any theoretical discussion. Now, that's very unusual. You rarely see judges say that their own personal experiences are the most important factor in their decision that they're about to describe, because that seems contrary to the rule of law. It's a personal kind of determination rather than an impersonal one. So there's a kind of paradox, which is that an opinion that is very personal now is seen as a very kind of sort of canonical statement of the impersonal rule of law. And I tried to get at how that happened, but it's not there's a little bit of a mystery still to that, I think, or magic, you might say. So his own experiences with President Roosevelt and dealing with Congress sort of shaped the view that there were these kind of rough delineations between the types of power that a president might have, depending on what Congress had or had not done. Now, also, he did get some of this from an opinion by Judge Augustus Hand, who was the sort of less famous cousin of Judge Learned Hand, who wrote an opinion in the 1920s, which basically laid out a very similar kind of framework, though not put quite as concisely, for judging executive power. And there's a note in the Jackson papers where he's telling presumably one of his clerks, perhaps William Rehnquist, who was one of his clerks at the time, to get the opinion from Augustus Hand in this case. And so you can see traces there as well. Now, the other thing worth pointing out is that most of the concurring opinion is not about the three categories that you've laid out. I mean, the three categories are the important analytical framework, but most of the opinion is talking about things like the nature of emergency power, or the nature of the presidency, or the division between civil and military power, which is why there's so much there to chew over when you're thinking about any number of cases. And even though some of it can be characterized as dicta, it's very interesting dicta, or it's dicta that has been very influential. So you have kind of the nuts and bolts of the opinion. Then you have this other discussion. And then finally, you have kind of this overall purpose or spirit, which you could describe either as pragmatic and practical, right? Which in Jackson was a pragmatic, practical person and had to be in all the different roles that he played in these different government positions, as Professor Barrett explained. But also, it's a kind of analysis which defies sort of easy characterization. So, in other words, it's not something that it's stating a rule or a clear answer. It's instead giving guidance, but guidance in a kind of professional way that people have found very useful over time and continue to find useful. So that's just the beginning, you might say, of sort of looking at the concurring opinion.
So interesting on all counts, including your insight about the fact that he relied on Judge Augustus Hand, and he had that great line about, quote, learn it and follow Gus, as well as relying on a secret memo written by, as you say, Assistant Solicitor General with the wonderful name of Golden W. Bell. What a mellifluous name that is. But you also show the complexity of his views about executive power and congressional power. John Barrett, how to account for that? I mean, he's Roosevelt's guy. He's defending executive power under Roosevelt so vigorously, and at the same time he has a sense of congressional prerogatives, leading him to write one of the more significant constraints on executive power in American history. Where did that come from?
Well, I think it came from a few places, but one very prominent place is Nuremberg. Before he went to Nuremberg, Jackson was a New York State lawyer, and he, across his career, is a federalism person. He is a bit suspicious of national power and believes in the prerogative of the states, state courts, state elected officials. To the extent he starts to encounter national power in Washington, it's both types. It's the executive branch that he's a part of, but it's also the legislative branch that he is testifying before constantly, and the legislative proposals that he is making constantly. This is 1935 through 1941. Jackson is never a member of Congress, but a real understanding of an appreciation for Congress is part of his pre-Nuremberg experience. Now, in 1945, he's on the court for 4 years at that point. President Truman, only 2 weeks in office, has inherited this war in Europe, which is about to be won, and an allied commitment that the arch criminals of Nazism will be held accountable in an international process. And so Truman reaches out, with the advice of Roosevelt inner circle people, to the man who they all regard as America's leading legal figure. Indeed, Harry Truman writes at the time, only one person is qualified to be president of the United States right now. It's Robert Jackson. And the request is that Jackson represent the United States in creating what becomes the world's first international criminal court, and a trial of what over the next year becomes the accountability process for waging World War II, committing war crimes, committing crimes against humanity. It's not the Hitler trial. He doesn't show up, obviously, but it is senior representatives of the sectors of Nazism. And what the core of the Nazi acquisition of power was before aggressive war was the conquering, the destruction, the deliberate extinguishing of parliamentary government, totalizing executive power. And Jackson is studying, immersed, prosecuting, learning that system, and it changes him fundamentally. He's also doing that work alongside Soviet colleagues, who, of course, represent a different kind of totalizing executive control government. And so when Jackson comes home to the United States in 1946, and then 6 years later, when the Steel Seizure Case pops up for the country and on the docket of the Supreme Court, Jackson really sees this as a fundamental question of which is our preeminent branch. What are our structural commitments in the Constitution? And Jackson saying, as Professor Magliocca described, I've been an executive branch man, by 1952 is saying, I can distinguish some matters I handled then with what this matter presents, or I've thought further and I've changed my mind. And what he really writes in the concurring opinion is a structural commitment to, of course, Article 1, to legislative government, to the place of the court in protecting the role of Congress. As Jackson says in a lovely couplet at the end of the opinion, it should be the role of this court to be the last, not the first, to give up the Constitution's commitment to the role of Congress.
Absolutely fascinating, noting the central influence of Nuremberg on Jackson's views about executive power. And you also note on the Jackson list that his experience at Nuremberg influenced his free speech opinions. And you published a piece by Yom HaShoah, who noted that Jackson's opinion in West Virginia against Barnett says that those who begin coercive elimination of dissent soon find themselves exterminating dissenters. And these show, as Yom HaShoah suggests, that he saw Barnett as being more than just attempting to coerce Jehovah's Witness school children in violation of their consciousness, but really a definition of the impossibility of coercing opinion in a liberal state. Professor White, you were focused on this crucial period between Nuremberg and the Steel Seizure Case, and why don't you give us your thoughts on that? Your account of Nuremberg is just amazing, including details about Jackson putting all his papers out on the bed despite his assistant's warning, and then having the whole thing get soaked in the rain and having to rewrite everything, to the centrality of both his opening and closing arguments to the legitimacy of the trials throughout the world. Tell us that story and the connection between Nuremberg and Jackson's later jurisprudence.
Yeah, let me talk about the relationship between his experience at Nuremberg and two free speech cases. The first you've talked about, Barnett. The line that you quoted is very informed. Barnett is 1943. That line is very informed by Jackson's perception of what is going on in Nazi Germany. That the Nazis have established a totalitarian state in which the government is controlling the lives of ordinary citizens in every conceivable way, including repressing their speech. And one of the things that Jackson is trying to set up in Barnett is a distinction between what goes on in the United States, where we allow freedom of speech, even where the speech is not valued or regarded as controversial. The idea that Jehovah's Witness children would not want to salute the flag being a symbol of the United States. Whereas the Nazis while the last resort of repressing speech is to exterminate those who are speaking in an unpopular fashion. So Barnett is a very free world, libertarian, pro-speech opinion. Now let's contrast that with the Terminiello case. Terminiello is a case where there's a riot in Chicago when Father Terminiello, a defrocked priest who has become a kind of rabble rouser for the right, going around and making anti-Semitic commentary and revving up his audiences, speaks at a rally and sets off a riot where people from the street are throwing rocks in, and there are clashes between Terminiello supporters and opponents. And the court basically says that what Terminiello did was not a true threat that could be suppressed by a municipal ordinance, and the ordinance that sought to suppress it was unconstitutional. It's a very cryptic opinion written by Justice Black without much factual detail on actually what happened. Jackson's concurrence is largely about that factual detail. And the general point of, after setting forth everything that happened, is Jackson wants his audience for the opinion to take away the message: these fascist sympathizers can do a great deal of damage. They are not just simple nuts. They are capable of inciting violence in a very significant fashion. And if you want an illustration of that, just look at Nazi Germany. Um, so this is a chastened, post-Nuremberg perspective on free speech. And I found the contrast very illuminating.
Absolutely fascinating. The idea that the pre-Nuremberg experience would alert Jackson to the dangers of coercing opinion in the post-Nuremberg, about the need perhaps to prevent speech from ripening into violence. And because I have to take the moderator's prerogative, any of us could do this, but I've got to have the pleasure of reading the best line from Barnett, which may be one of the best lines in all of Supreme Court history. Jackson says, "If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." I must ask, Professor White, why is that such a great line?
Well, that's classic Jackson, in the sense that he's making a point that many people who are supporters of free speech have made. The point is basically that if we want to have a democratic society, we need to have a society in which people cannot become officials of one kind or another and then tell the rest of us how to think or how to express our thoughts. It is just endemic in American civilization that we have that understanding that people can be free to criticize the government, free to say what they like, and that high or petty officials cannot tell them what to do. But it is packed with wonderful Jackson metaphors and analogies. If there's any fixed star in our constitutional constellation. I mean, he had just the ability to take a particular thought, perhaps a familiar thought, and express it in a remarkably original and vivid way. That's why he's one of the only two Supreme Court justices whose writings have been anthologized. The other is Oliver Wendell Holmes,
who you've also written vividly about. I think that's such an illuminating answer. The thought that you can't coerce opinion is familiar. It goes back to Madison, the Memorial and Remonstrance, that the opinions of men, being dependent on evidence contemplated by their own minds, cannot be controlled by other men. But that's abstract, whereas, as you say, Jackson makes it concrete through metaphor of the fixed star in our constitutional constellation, and it just fixes in the mind in the most vivid and memorable way. Thank you for that. Gerard Magliocca, you talk about the legacy of the Steel Seizure Opinion. It became central during the Watergate era in cases constraining executive power, and it was carried forward by William Rehnquist, a clerk of Justice Jackson in the Dames and Moore case, and then by John Roberts, a clerk of Rehnquist, and therefore indirectly of Jackson once removed, in the Trump v. U.S. Tell us about the lasting effects of the Steel Seizure case.
Well, the case becomes important during Watergate because people are looking for an authority to refute President Nixon's claim that he did not have to turn over the tapes. And Nixon's claim in that litigation was that the executive branch was, in some sense, hermetically sealed from the other branches, and that they could not intrude upon the executive in any way. And of course, the concurrence very much stresses the interdependence or reciprocity between the three branches, that yes, there is separateness, but there is also a kind of integration among them, and that it's all designed to produce a workable government that is balanced and supporting kind of broader constitutional principles, including the important role that Congress serves as the sort of people's representatives will. Now, So that's when the case is cited extensively by Archibald Cox, the special prosecutor, and then for the first time quoted by the Supreme Court in U.S. v. Nixon, ordering that the tapes be turned over. So that kind of launches the case into a whole new realm, in part because Congress then, after Watergate, relies on Justice Jackson's analysis in writing various statutes that purport to limit the president's power in one way or another. And then the court kind of formalizes this in the Dames and Moore case, written by Justice Rehnquist, which ironically concerned the IEPA statute, which is now the subject of litigation in the tariffs case. So there, the court formally adopts the framework that you described earlier of the three categories that Justice Jackson laid out as being the way to understand the scope of congressional and presidential power when they come into conflict. Now, the real question that we're in thinking about sort of the next generation of the Steel Seizure concurrence is how that might speak to the question of interpreting statutes that purport to confer or that are claimed to confer broad executive power. That is, in Youngstown, everybody conceded that President Truman did not have the power via statute to seize the steel mills. So the analysis focused on whether there was some Article II power. All right, but what if there is a statute that is purporting to confer power on the president? Well, how should that statute be construed? Now, one way to look at what the concurrence says is, well, it has nothing to do with that. Basically, it doesn't speak to that issue at all. But another way to look at it is that it does speak to that question because all of these other statements, which I described earlier as the sort of bulk of the opinion that's very interesting, all raise concerns or express values that might come to bear on how a kind of ambiguous congressional statute should be interpreted. So I think we'll find out soon in the coming months whether the opinion is going to sort of take a new step forward or be kind of recast somewhat for the kind of more modern 21st century questions of separation of powers, or whether it's going to be sort of limited and treated a little bit more like a kind of a museum piece that one quotes or cites, but doesn't use to really actually invalidate executive action. So that's, I think, where we'll see the rubber hit the road this term.
Absolutely, it will be crucial, and Jackson may well be at the center of it. John Barrett, give us a sense of the legacy of Nuremberg. First, tell us about the movie. You mentioned that you'd seen it, but share with our audience whether or not they should see it. And then tell us, Jackson's ambition is to show the world that it was possible to try war crimes under the rule of law. And rather than summary executions, he insisted on fair procedures and was determined to vindicate the rule of law in international affairs. Did he succeed? How was his performance? There was the famous moment where he seemed to be rattled by Goering when the court allowed Goering to go on in his responses, and Jackson seemed to get unnerved, but on balance, especially given the success of his opening and closing arguments. Was he a success at Nuremberg, and what is the legacy of Jackson at Nuremberg?
Yeah, I think he was a success, really a quite high success at Nuremberg. You're right to identify the fork in the road, the choice that really is the beginning of Nuremberg, because Jackson is a lawman, a rule of law man, a due process man. And he says publicly and privately to Harry Truman that, of course, you have won the war. You've obtained an unconditional surrender by the Nazis. They are in your hands and you can dispatch them with executive power. But then I'm not the man for the job. That is a military, a drumhead court, a summary execution. If you want the law to come in, there are legal standards, processes, and values that will take some time, but that can sort of bring a restoration of law to the aftermath of war. And Truman says, that's exactly what I want. That's why I've asked you to take this job. And so Jackson negotiates with allies, sort of defeats the Soviet impulse for a show trial, and then creates with his colleagues a Nuremberg tribunal that really has procedures that much resemble our Bill of Rights. It is a four-nation court that proceeds in public. The judges don't work for the prosecutors. The prosecutors have to carry a burden of proof. The defendants have the right to a public written indictment. They have an opportunity to prepare themselves for trial. They have liberal discovery. They have compulsory process to call witnesses in their own defense. They have the right to take the stand or not in their own defense. It's really quite familiar, not, all fours with the Bill of Rights, but quite familiar to Anglo-American legal tradition. And that takes the better part of a year. Jackson does open the trial in November with a brilliant opening statement. He handles a considerable number of witness examinations. Some are devastatingly effective. Some are bumpier. His 3-day cross-examination of Goering does have a couple of divots, no question about it. But by the end is, I think, quite successful. And if you read the press at the time, there's a lot of lauding in addition to some criticism of Jackson. He has I would say, bumpier cross-examination of another defendant, Hjalmar Schacht, the economics minister, and he has a much stronger cross-examination of another defendant, Albert Speer. And then Jackson delivers a closing in July of 1946 that is also quite masterful. By doing it this way, the rule of law way, in public, on documents, with witnesses, all transcribed before the world in press corps and newsreel, it provides a basis to feel confident that these are fair judgments against the defendants, and to have a historical record that allows us 80 years down to understand what the Nazis were and what they had done. And that is really precedent in so many ways for progress in learning, in rights, and in rule of law. Now, the Nuremberg film that you mentioned, which premiered last month, I'm not sure if it's still in theaters, but certainly it'll be streaming, is filled with wonderful acting. It has Russell Crowe playing Hermann Goering, Michael Shannon playing Robert Jackson, Rami Malek playing the prison psychiatrist. And it's based on a fine book by a journalist about the relationship between the psychiatrist and Goering. The script, however, goes beyond all of that empirical material and sort of imagines the psychiatrist into courtroom scenes that didn't occur, and imagines courtroom scenes in general that didn't occur, and a kind of clandestine corruption by Jackson of the doctor-patient privilege that the psychiatrist, I guess, owed Goering, even though it was a prison psychiatrist and so forth. So, Hollywood took some liberties, but I think it generally is important for people to know and study Nuremberg. And to that extent, the film is a contribution.
That is great. Thank you for that judicious verdict. And my son Hugo just saw it and liked it. So there's a good recommendation from the college set. I'm looking forward to seeing it too. Professor White, as we begin to wrap up, let's talk about the aspects of Jackson's judicial legacy that we haven't touched on yet, including his path to voting with the majority in Brown v. Board of Education. He was reluctant at first to strike down segregation based on the history and tradition and original understanding of the 14th Amendment, which he thought clearly allowed segregation. But he came to believe that changing economic, social, and political conditions since the Civil War had transformed the Due Process and Equal Protection Clause. So he was not an originalist by any means, but he did favor judicial deference to democratic outcomes, and at the end of his life wrote an unpublished manuscript criticizing his more activist colleagues for trying to second-guess democratic decision-making. How would you give us a sense of Jackson's textured judicial philosophy and his performance broadly on the court?
Well, first, let me say a little bit about Brown versus Board of Education. His performance in Brown versus Board was, again, classic Jackson. When Jackson was uncertain about how he was going to come out with a case, when he was troubled about a case, he would write memoranda to himself. And in Brown versus Board, he wrote 6 drafts of what he may have intended to be a concurring opinion. Jackson was a fan of integration in the sense that he thought desegregation was wrong. he was very troubled about what the legal basis for overruling Plessy versus Ferguson might be. As you've said, he doesn't get much support from the 14th Amendment because at the time of the 14th Amendment's passage, there were segregated schools, and they continued after the passage of the 14th Amendment. So there are various problems, including the fact that Plessy had been a precedent for many years. He had trouble finding a legal basis for it. He was aware in the course of the 53-54 term that his colleagues were gradually moving in direction of reversing Plessy and getting rid of racial desegregation in public education. He was aware that he was a holdout in embracing that, and he tried to find ways in which he could find comfortable joining it. And one of the ways he came up with was a perception that that African Americans were integrating themselves increasingly and successfully into the business and professional communities. That observation, based on someone who had very little experience, you grow up in the North, he had very little experience with African Americans at all, and very few African Americans are in business and professions in Jamestown, New York. That observation seems a little naive, but Jackson wanted to work his way toward concurrence. There's a story I tell in the book about Barrett Prettyman, one of Jackson's favorite law clerks, visiting Jackson in the hospital along with Earl Warren. And Jackson and Prettyman get together, and Warren shows them the draft. And Jackson says to Prettyman, "What do you think?" And Prettyman says, "Well, I don't think there's a lot of law in it. Maybe you could use a little more law." So Warren and Jackson have a conversation in which Jackson communicates this to him and also tells him his part about what he thinks is the increased participation of African Americans in the business and professions. That line finds its way into the opinion. No additional law finds its way into the opinion. I think that's a sort of classic Jacksonian performance. He's independent. He's always independent on the court. He's always working out things for himself. He deeply resents people trying to pressure him or lobby him. He's not a coalition builder. He's not particularly collegial. He would probably not have been a particularly effective Chief Justice to the extent that the Chief Justice is those factors, collegial. He's not fully fulfilled on the court, I think. I think he was correct to say that Nuremberg was the high point of his experience. I think he's also correct to say that he was deeply troubled at times on the court, his controversy with Black. So all in all, his legacy as a justice is a somewhat ambiguous one. Highly successful in some respects, unfulfilled in others. His legacy as, if you want to say, a statesman, as a person spanning various roles, is to my mind very significant. He's one of the great statesman-like figures of his generation.
Beautifully put. Gerard, brief final thoughts in our last moments about the legacy of Robert Jackson.
Well, when I was thinking about the cover for my book, I chose a picture of Jackson testifying before Congress when he was an executive branch lawyer. And the reason for that is to say that, first, the importance of the role of Congress, the importance of the role of consultation between the branches, and those are themes of his concurring opinion and of his career more generally, but also that there are no shortcuts in constitutional law. And presidents are always trying to find shortcuts because they don't want to deal with Congress. It's a lot of people. They have to make a lot of promises. They always prefer to issue an executive order or do something unilaterally if they can, but that's not how our system works. And Justice Jackson captured that well in his statement that the executive needs to be under the law and the law needs to be made by parliamentary deliberations. That comes at the end of the opinion. And so the cover was my attempt to represent that principle, and that's the principle for which the Steel Seizure opinion lives on.
Well, wonderful. And John Barrett, last word to you on the subject to which you have so nobly devoted your career, and that is the legacy of Robert Jackson.
Yeah, I think Robert Jackson is of permanent significance. It includes the Justice Jackson part, but includes what I described as the statesman part, the life and career. It's thus a pleasure to assist and incubate other people's project. I think the world needs a shelf full of Jackson books and different kinds of study. And so these two add to the existing ones, and more are in the works. Nuremberg biographies, etc. Jackson makes everyone lift their game. Because if you look at how he operated, he thought hard, he worked hard, he devoted himself to his craft, and he really tried on the page with his pen to be honest with himself, to work out his explanations. He didn't sort of let himself off easy with a quick reflex or a pre-commitment. And I think those are enduring virtues.
Hear, hear. And all three of you have modeled those virtues of inspiring all of us to up our game in this great conversation. It was such an honor to co-host with the Robert H. Jackson Center, which I'm looking forward to visiting this summer, and which all of our viewers should visit in Jamestown, New York. And on behalf of the National Constitution Center, thank you so much, Professor White, Magliocca, and Barrett, for an inspiring discussion of the eloquent and meaningful legacy of Justice Robert Jackson. Thanks to all.
Thank you.
Thank you.
This episode was produced by Bill Pollack and Griffin Ritchie. It was recorded by Scott Bomboy, David Stotts, Greg Scheckler, Kevin Kilburn, and mixed by Bill Pollack. Research was provided by Griffin Ritchie, Anna Salvatore, Trey Sullivan, and Tristan Worsham. Friends, it is the holidays. What a great time to get my new book, The Pursuit of Liberty, How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. If you'd like a signed book plate, please let me know at jrosen@constitutioncenter.org. And thank you for checking out the Pursuit podcast. All 12 episodes are now up. Pursuit, the Founder's Guide to Happiness. It was such an honor to co-host with Ken Burns and talk to great American historians about the founder's quest for self-mastery. Please recommend the show to friends, colleagues, or anyone anywhere who's eager for a weekly dose of constitutional illumination, exploration, and debate. And always remember that the National Constitution Center is a private nonprofit. This podcast and all our work is only possible thanks to the generosity of people from across the country who are inspired by our nonpartisan mission of constitutional education and debate. What a great time at the end of the year to make a donation. You can do that by donating today at constitutioncenter.org/donate. And if you want to send me a note, if you like the podcast and you find it meaningful as part of your lifelong learning, I would love to hear from you. On behalf of the National Constitution Center, I'm Jeffrey Rosen.